Stop everything you're doing right now. If you have a family-based immigration petition pending or you're planning to sponsor a family member to come to the United States, this news is absolutely critical. USCIS just announced major changes to the I-130 family visa process, and these changes take effect in January 2026. That's just around the corner. Will these changes speed up your case or slow it down? Could you be missing out on new opportunities? And what mistakes should you avoid that could jeopardize your petition? Stay with me because what I'm about to share could make the difference between success and denial, between months of waiting and years of separation. Welcome to US Visa Info, your #1 source for the latest updates on immigration, visas, and everything you need to know about navigating the United States immigration system. I'm here today to break down the brand new I-130 family visa changes that USCIS has just announced. And believe me, these are some of the most significant updates we've seen in years. Whether you're a U.S. citizen trying to bring your spouse, parents, children, or siblings to America, or you're a green card holder sponsoring immediate family members, these changes will directly impact your immigration journey. Here at US Visa Info, we cut through the confusion and give you clear, actionable information you can use right away. Make sure you watch until the very end, because I'll also share insider tips on how to prepare your petition for success and avoid the common pitfalls that delay or even derail family visa applications. Let's get straight into what's changing with the I-130 petition starting January 20th to 26th. The I-130, officially called the Petition for Alien Relative, is the first crucial step in family-based immigration. It's how U.S. citizens and lawful permanent residents sponsor their eligible family members for green cards. USCIS has announced several key modifications to the process, fees, processing times, and requirements, and you need to understand each one. First and foremost, there's a significant change to the filing fees. Starting January 1st, 2026, the fee for Form I-130 will increase from $675 to $710. That's a $35 increase per petition. Now, if you're only filing one petition, $35 might not seem like a huge deal. But consider this. Many families file multiple I-30 petitions simultaneously, perhaps for a spouse and children or for multiple siblings. Those fees add up quickly. If you're planning to file and you can get your documents ready before January 1st, you could save money by submitting under the current fee structure. However, don't rush and submit an incomplete or poorly prepared petition just to save $35. A denied petition will cost you far more in terms of money, time, and emotional stress. But here's where it gets more interesting. USCIS is also introducing changes to premium processing for certain I-130 categories. Up until now, premium processing, which guarantees a decision within 15 business days for an additional fee, hasn't been available for I-30 petitions. Starting in January 2026, USCIS will begin a pilot program offering premium processing for specific immediate relative categories. This initially includes I-30 petitions filed by U.S. citizens for their spouses. The premium processing fee will be $1,100 on top of the regular filing fee. Yes, that's expensive, but for couples who are separated and desperately want to be together, or for those who have urgent circumstances, this could be a game changer. Instead of waiting 12 to 18 months or even longer for a decision, you could potentially get approval in just 15 business days. However, and this is crucial, premium processing doesn't speed up the entire immigration process. It only expedites the USCIS decision on the I-30 petition itself. Once your I-130 is approved, you still need to go through consular processing at a U.S. embassy or consulate abroad or file for adjustment of status if your beneficiary is already in the United States. Those steps have their own timelines and can't be expedited through premium processing. So, while premium processing can help you clear one hurdle faster, you need to understand it's not a magic solution to get your family member to the U.S. overnight. Another major change involves the documentation requirements. USCIS is implementing stricter guidelines for proving the legitimacy of relationships, particularly for spousal petitions. They're seeing an increase in fraudulent marriage cases, and as a result, they're requiring more substantial evidence of bona fide marriages. Starting January 2026, you'll need to provide more comprehensive documentation of your relationship. This includes additional photos together spanning the course of your relationship, more detailed statements from friends and family who can attest to your relationship, evidence of shared financial responsibilities like joint bank accounts, joint leases or mortgages, shared utility bills, and documentation of communication if you had a long-distance relationship before marriage. For parent-child relationships, USCIS is also tightening the requirements for proving biological relationships. Birth certificates must now be long-form certificates that clearly show both parents' names. Short-form birth certificates that only show the child's information will no longer be accepted unless accompanied by additional documentation, like DNA testing results or affidavit. This is particularly important for cases where the birth certificate is old, damaged, or from a country with unreliable vital record systems. Let's talk about processing times because this is what everyone wants to know. USCIS has committed to reducing overall processing times for I-130 petitions, and they've set ambitious goals for January 2026 and beyond for immediate relative petitions filed by U.S. citizens for spouses, parents, and unmarried children under 21. USCIS aims to process cases within 9 to 12 months at most service centers. This is actually an improvement compared to current processing times, which can stretch to 15 or 18 months at some centers. For family preference categories, which include married children of U.S. citizens, children of green card holders, adult unmarried children of U.S. citizens, and siblings of U.S. citizens, processing times will vary more widely. These categories are subject to annual visa caps and priority date backlogs, so even after your I-130 is approved, there could be years of waiting before a visa becomes available. Here's something many people don't understand about family preference categories. The approval of your I-130 petition establishes your priority date, which is essentially your place in line for a visa. Even though USCIS might process your petition faster starting in January 2026, you'll still need to wait for your priority date to become current based on the visa bulletin published monthly by the Department of State. For some countries with high demand, particularly Mexico, Philippines, India, and China, these wait times can be extremely long. Siblings of U.S. citizens from these countries, for example, might wait 15 to 20 years or more before a visa becomes available. Now let's discuss some critical changes to how USCIS evaluates the sponsor's ability to financially support the immigrant. The Affidavit of Support, Form I-864, remains a requirement for most family-based immigration cases. The sponsor must prove they have income or assets at least 125% of the federal poverty guidelines for their household size. Starting January 2026, USCIS will be more stringent in reviewing these affidavits. They're requiring more recent tax returns, pay stubs from the last 6 months instead of 3 months, and additional documentation if you're self-employed. If your income doesn't meet the requirements, you'll need a joint sponsor. And that joint sponsor must now provide even more detailed financial documentation than before. The key here is to make absolutely certain your financial documentation is complete, current, and clearly demonstrates your ability to support your family member at the required income level. Another important update relates to cases where the beneficiary is already in the United States. If your family member is in the U.S. on a valid non-immigrant visa and you're filing an I-130 for them, you need to be very careful about their intent. USCIS is paying closer attention to cases where someone entered the U.S. on a non-immigrant visa, like a tourist visa or student visa, and then immediately had an I-130 filed for them. This can be seen as visa fraud or misrepresentation of intent at the time of entry. The new guidelines emphasize that if you plan to file an I-130 for someone who's currently in the U.S., there should be evidence that circumstances changed after their entry, such as a marriage that occurred after they arrived. If you married before they came to the U.S., but they told the consular officer they were coming for tourism only, that's a major red flag. Let me share some crucial action steps you should take right now to prepare for these changes. First, if you're planning to file an I-130 petition and your case is ready, consider filing before January 1st if possible to avoid the fee increase and to get in under the current guidelines. However, and I can't stress this enough, never rush your application. A complete, well-documented petition filed in January under the new rules is far better than a hastily prepared petition filed in December that gets denied. Second, start gathering your evidence now. Don't wait until you're ready to file to start collecting documents. Get certified. Copies of birth certificates, marriage certificates, divorce decrees, if applicable, and start organizing photos, financial documents, and other evidence of your relationship. The more thorough you are up front, the less likely USCIS will issue a request for evidence, which adds months to your processing time. Third, make sure you meet all the eligibility requirements before you file. U.S. citizens can sponsor spouses, unmarried children of any age, married children, parents if the citizen is at least 21, and siblings if the citizen is at least 21. Lawful permanent residents can sponsor spouses and unmarried children only. If you don't meet these relationship requirements, your petition will be denied and you'll lose your filing fee. Fourth, be completely honest and accurate on your forms. Immigration fraud is a serious offense that can result in permanent bars to entering the United States. Double-check every answer, every date, every name spelling. Use legal names as they appear on official documents. If you've ever used other names, disclose them. If you have a criminal history, disclose it. USCIS will find out anyway, and lying on your petition is far worse than admitting to past issues up front. Fifth, consider working with an experienced immigration attorney, especially if your case has any complications. This includes situations where the beneficiary has been in the U.S. unlawfully, has criminal history, was previously denied a visa, or has other issues. An attorney can help you navigate these complexities and present your case in the best possible light. While hiring an attorney costs money, it can save you from costly mistakes and potentially years of delays. Let's also address some common mistakes that applicants make with I-130 petitions. One of the biggest mistakes is submitting insufficient evidence of the relationship. USCIS wants to see clear, convincing proof that your relationship is genuine. For marriages, this means showing that you have a life together, not just that you went through a marriage ceremony. Submit photos from throughout your relationship, not just from the wedding day. Include evidence of ongoing communication, especially if you have a long-distance relationship. Show that you know personal details about each other by providing detailed relationship statements. Another common mistake is failing to properly translate documents. All documents submitted to USCIS must be in English or accompanied by certified English translations. The translator must certify that they're competent in both languages and that the translation is complete and accurate. DIY translations from Google. Translate or unofficial translations are not acceptable and will result in rejection of your petition. Some applicants also make the mistake of not keeping copies of everything they submit. You should make complete copies of your entire I-130 packet before you mail it. This includes the forms, all supporting documents, photos, and the check or money order for the filing fee. If USCIS loses something or requests additional evidence, you'll need to know exactly what you already provided. Timing is another area where people make mistakes. Don't wait until the last minute to file. Immigration processing takes time and unexpected delays happen. If you have time-sensitive circumstances like a job offer, pregnancy, or medical issues, build in extra time and consider using premium processing if it's available for your category. Let's talk about what happens after you file your I-130 petition. Within a few weeks, you should receive a receipt notice from USCIS confirming they received your petition and providing a receipt number. This number is crucial. You'll use it to check your case status online, and you'll need to reference it in any correspondence with USCIS. Once USCIS begins processing your petition, they may request additional evidence if they need more information to make a decision. If you receive a request for evidence or RF, respond completely and by the deadline. Failure to respond or submitting an inadequate response will result in denial of your petition. If your I-130 is approved, what happens next depends on where the beneficiary is located. If they're outside the United States, the case moves to the National Visa Center for Consular Processing. The NVC will contact you about paying additional fees and submitting more documents, including the affidavit of support and civil documents for the beneficiary. Eventually, the beneficiary will attend an interview at a U.S. embassy or consulate. If they're already in the United States in valid status, they may be eligible to file Form Y-485, application to register permanent residence, or adjust status to get their green card without leaving the country. One important aspect of the January 2026 changes is enhanced communication from USCIS. They're implementing a new online portal that will provide real-time updates on case status, allow you to submit documents electronically in response to RFEs, and enable secure messaging with USCIS officers. This is a huge improvement over the current system, where you often wait weeks or months without any information about what's happening with your case. Make sure you create a USCIS online account and link your case to it so you can take advantage of these new features. Looking ahead, USCIS has indicated that additional changes may be coming later in 2026. They're exploring options for expanded premium processing to other family preference categories, potential pilots for video interview options instead of requiring in-person interviews for certain low-risk cases, and enhanced fraud detection systems using artificial intelligence to identify patterns consistent with fraudulent petitions. While these future changes are still being developed, it's clear that family-based immigration is evolving, and staying informed is more important than ever. The bottom line is this: the I-130 family visa changes starting January 2026 represent both opportunities and challenges. Higher fees and stricter documentation requirements mean you need to be more prepared than ever. But faster processing times and new premium processing options mean you could potentially be reunited with your loved ones sooner. The key is understanding these changes, preparing thoroughly, and submitting a complete, accurate, well-documented petition. These I-130 changes are significant, and I hope this comprehensive breakdown has given you the information you need to move forward with confidence. Here at US Visa Info, we're dedicated to keeping you updated on every change to U.S. immigration policy and helping you successfully navigate this complex system. We know how important it is to bring your family together, and we're here to support you every step of the way. If you found this video helpful, please subscribe to US Visa Info and hit that notification bell so you never miss an important update. We cover breaking news on all visa categories, policy changes, processing times, and everything you need to know about U.S. immigration. Share this video with anyone who's going through the family visa process or planning to sponsor a relative. Knowledge is power, and the more informed our community is, the better prepared we all are. Leave a comment below and let me know your situation. Are you filing an I-130 soon? Are these changes affecting your plans? Do you have questions about your specific case? I read every comment and do my best to provide guidance. The US Visa Info community is here to help each other succeed. Until next time, stay informed, stay prepared, and don't give up on bringing your family to America. Your dream is possible with the right information and preparation. Take care, and I'll see you in the next update from US Visa Info.